Hello everyone, welcome to the U.S. Immigration News. Families waiting years for a green card. No one date can change everything. A single birthday could mean a child stays protected, or loses their chance forever. With USCIS's latest policy shift, that fear of aging out is more real than ever. In this video, we're going to unpack a sudden policy shift from USCIS that could decide whether a child keeps protection under the Child Status Protection Act or ages out and loses their place in line. If your family has been waiting for years, if your son or daughter is counting the months, this update matters in a very real, very personal way. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now let's get into the video. Let's start with what changed, because the words sound technical, but the impact hits home. USCIS has updated the way it calculates a child's age under the CSPA. For years, families have been watching two charts every month in the State Department's visa bulletin, one called Final Action Dates and the other called Dates for Filing. Until recently, many adjustment applicants relied on the friendlier, earlier dates for filing to argue that a visa was available for the purpose of locking in a child's age. As of mid-August 2025, USCIS has clarified that, moving forward, the agency will use the stricter Final Action Dates chart to decide when a visa is considered available for CSPA age calculation. That single shift, from one column to the other, can be the difference between a teenager being safely under 21, or suddenly counted as over 21 and pushed into a different category. The date matters. USCIS says this guidance takes effect on August 15, 2025. If you're filing your adjustment of status on or after that date, the Final Action Dates chart governs whether your child's age can freeze under CSPA. That means families timing their filings around a brief forward movement in dates for filing now face a new reality. It isn't enough for that friendlier chart to advance. Your category typically needs to reach the stricter Final Action Date line before your child's CSPA calculation can lock. There is one more part you need to hear clearly because it offers a lifeline to some. USCIS has indicated it will continue to apply the February 14, 2023 approach to cases that were already pending with USCIS before August 15, 2025, acknowledging that many families strategically filed relying on that earlier guidance. In plain English, if your adjustment was already in the system before August 15, USCIS says it will respect the policy that existed when you filed. That doesn't fix everything, but it is a nod to fairness for those who acted in good faith. If you're new to CSPA, here's the heart of it without the jargon. The law tries to stop children from aging out during the long wait for a green card. It does that by freezing or offsetting part of a child's age once a visa is considered available under the rules. But the definition of available is everything. The earlier guidance allowed many to rely on dates for filing to trigger that protection. Now, for new filings, the bar is higher. You generally need the Final Action Date to be current in your category before CSPA can lock your child's age. For families in backlogged categories, like certain family-based and employment-based lines, this can mean months or years of additional uncertainty. Think about a parent who has waited with their daughter since she was 16. They planned every step around an expected filing window, watching the visa bulletin like a heartbeat. Maybe the dates for filing chart moved just enough to let them submit adjustment paperwork and believe the child's age would be protected. Under the new policy, if they file after August 15, that calculation doesn't start from dates for filing anymore, it starts from Final Action Dates, which moves slower. And when you're counting down to a 21st birthday, slower feels like an alarm bell, not a technical note. Let's also talk about timing and how it collides with the calendar right now. We're heading into the September 2025 Visa Bulletin, the final bulletin of the fiscal year, and those last month movements sometimes shuffle priority dates as agencies try to balance annual visa numbers. If you're in a family-based or employment-based line, you know how a few weeks can change everything. But under this new approach, you're watching Final Action Dates for CSPA, not just dates for filing. So when you open the September chart, you need to ask one question first: is my Final Action Date current? If yes, your child's CSPA protection can likely lock with a properly filed adjustment. If no, you're still in a risk zone, even if dates for filing looks encouraging. A lot of you write to us about the National Visa Center, about document sitting, about consulate scheduling interviews months apart, about RFEs that feel technical but carry real consequences. This change ties all of that together. If your green card path runs through a consulate abroad, you still track the Final Action Dates, because interviews can only be set when a number is actually available. If you're adjusting inside the United States, you now need those same final action dates to claim CSPA protection for a child on filings after August 15. For families, this means the NVC's email timing, your DS-260 readiness, your civil documents, and the way your local consulate handles calendars all intersect with one critical column of the visa bulletin. I know some of you are asking, is this political? The answer is that immigration is always shaped by politics, and this year has been intense. The Trump administration's broader enforcement posture, the legal fights around federal authority, and the messaging around vetting and processing timelines have all created a climate where agencies emphasize stricter readings and tighter controls. Whether you agree or disagree with that approach, the real question for your family is how to navigate it. For many, that means planning around final action dates and building fallback strategies if the dates stall. Context: current headlines have focused on enforcement surges and authority battles while families worry about practical timelines. What should you actually do right now if you have a child nearing 21? First, pull out your priority date and check your preference category in the latest visa bulletin. Then, look at final action dates for your country of chargeability. If your date is current, talk to your attorney about filing immediately and documenting your child's age calculation under CSPA. If your date is not current, this is the time to review every piece of your case so that the moment the final action date becomes current, your adjustment or consular case is ready to move. That means your civil documents are updated, your medical exam plan is in place, your fees are set, your I-864 or financial evidence is current, and you understand the order in which NVC or USCIS will ask for each item. I say this because the window can be short, and the difference between being almost ready and truly ready can decide whether a child keeps protection. For families already pending before August 15, 2025, the message is different. USCIS has said it will apply the older policy to those pending adjustments, recognizing that many relied on it when they filed. If that's you, it's still smart to confirm in writing, through counsel or through careful response to any RFE, that your case falls into that pending before August 15 category and that your child's CSPA analysis rests on the earlier guidance. Keep proof of filing dates and receipts close. If an officer raises questions, you want to respond with clarity and speed. Let's also face something that rarely gets said out loud in official updates: the human cost of waiting. Children live for years not knowing if they'll be allowed to enter college as dependents, whether they can accept internships, whether they'll be forced to separate from parents at a birthday the law treats like a cliff. A policy change is never just text, it shows up at the dinner table and in long car rides home from school. When I speak to parents and kids about CSPA, I hear the same mix of hope and exhaustion, and that is why this shift from dates for filing to final action dates hurts. It removes a cushion many were counting on and replaces it with a stricter gate that sometimes opens later than expected. Now, zooming out, how does this fit into processing timelines across the system? We're in a year where visa number usage, backlogs, and agency staffing all collide. Your local field office might be moving faster on some categories and slower on others. The NVC might appear to hold cases while consulates catch up on interviews. And all the while, families are trying to predict whether the visa bulletin will advance enough to pull their case into the present. In this environment, understanding that CSPA now keys off final action dates for new filings helps you read each monthly bulletin like a map. It also helps you advocate for your case when a mistake happens, because yes, sometimes agencies misread their own charts, and you need to be able to point to the exact line that governs your filing month. Some of you are wondering if this increases the chance of RFEs or interview questions centered on age. It can. Officers now have a clearer instruction to look for true visa availability as shown by final action dates when assessing CSPA for new filings. That may translate into requests asking you to explain your calculation or to provide proof of the visa chart that applied in your month of filing. Be prepared to print the relevant visa bulletin page, highlight your category, and show how the child's CSPA age was computed on that date. Complete answers reduce delays. That's all we have for this bulletin. The U.S. Immigration News Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you haven't already, Please subscribe to the U.S. Immigration News channel. Thank you for watching, and we'll see you in the next video.